Minami interview. Take one, marker.
Okay. My name is Dale Minami. I was involved in the case that overturned his conviction. I had also read about these cases in the Korematsu case, landmark case that all law students read in law school. My parents were victims of the government incarceration of Japanese Americans. So I knew this from a personal point of view and a legal point of view. December 7th, 1941, the imperial forces of Japan attacked the United States at Pearl Harbor. And that day of infamy, as President Roosevelt calls it, led to years of infamy with the imprisonment of Japanese Americans suspected as being spies and saboteurs. 120,000 Americans of Japanese ancestry were banished from their homes, taken to the nether reaches of this country, imprisoned for indefinite periods of time, without any due process rights of a right to an attorney, right to a hearing, right to notice of charges. They lived in abysmal conditions for years. But the story begins before Pearl Harbor, because the years of racism that was visited upon Chinese Americans first, and then Japanese Americans, was begun years before, 100 years before. So this whole setting of the incarceration was pre-staged by the racism that afflicted Asian Americans. So the time was ripe, in a sense, for that racism and the rivers of racism to overflow. And so the country was predisposed to be hostile and antagonistic to Japanese Americans. And so it wasn't a difficult move for them to, claim that Japanese Americans were spies and dangerous. The incarceration of Japanese Americans was not an aberration. It had begun years and years ago with the first advent of Chinese to this country, who were welcomed initially as cheap labor and eventually became the subject of hostility, antagonism. They were segregated in schools. They were denied certain occupations. There were actually lynchings, killings, burning of their communities. And finally, in 1882, the first Immigration Act against any ethnic group was passed against Chinese from coming to this country. And into that void, since Chinese could not come, Japanese were recruited from Japan. And they both inherited the goodwill of Chinese at the start and then inherited the antagonism later on as they developed their own farms, became competitive to non-Asian farmers. And so the second Immigration Act was passed to ban Japanese in 1924. So that whole setting of racism or discrimination against these Asians was a stage for the incarceration of Japanese Americans. Their whole communities were burned down. Again, they were denied occupations with the state, segregated. They were not allowed to own land as immigrants, and that wasn't changed until the 60s. They couldn't marry outside their race. That was illegal, miscegenation. They also suffered a number of other legal discrimination from other areas. My grandparents came here in the early 1900s from the south of Japan, where many Japanese came because they were farmers, a whole host of historical and societal, cultural conditions. They thought, like the Chinese, they would stay for a little while, pick up the gold bricks that the streets were made of, return home and live like kings, and essentially were sold a bill of goods because they were then relegated to the railroads, mining, the most menial conditions in order to survive. They spoke Japanese, but so I couldn't communicate with them. And part of that reason is growing up as a third generation. My parents were born in Southern California. They discouraged us from knowing much about Japan, being too, quote, Japanese, because that would be a sign that we were vulnerable. And so we never talked about those, the imprisonment. We didn't talk about the injustice. We didn't talk about the hardships they went through. They did not like to talk about those issues. In order to assimilate and become part of this great American salad, however you want to call it, they felt that having too much trappings of being Japanese was a deficit, was something that you did not want to do, to call attention to yourself. So while we, occasionally ate Japanese food, we were pretty much encouraged to be as Caucasian as we could, as, quote, American as we could. And I think, as one commentator mentioned, they were like rape victims. This is not something pleasant to talk about. This was a horrible situation, a terrible injustice to a country by a country they loved. And for them, it was, they'd rather leave that in the past, the dark recesses of their minds, and try to, in a sense, protect us psychologically and in terms of our future careers as well. President Roosevelt, on February 19, 1942, signed Executive Order 9066, which delegated to the military commander of the Western states, Lieutenant General John L. DeWitt, to make such orders as appropriate. Congress, within a day or two, passed Public Law 503, which made it a crime to disobey a military order. And it's a military order that was yet to be issued. So it's all very, staged and coordinated. Then the military commander, John L. DeWitt, orders a curfew, first, of all alien Germans, Italians, and all Japanese, whether citizens or not. That led to an exclusion act that was aimed at Japanese, whether you're an American citizen or not, where they had to leave their homes and they had to report to certain, they call them temporary assembly centers, which for my parents was the Santa Anita racetracks, where they lived in horse stalls with horse manure on the wall and hay on the ground. And then they were moved and transported across the country to Rohwer, Arkansas, or one of the 10 other designated camps for Japanese Americans. And that was the years of infamy I mentioned. It was years of infamy for Japanese to have nothing to do with Pearl Harbor and yet be taken away without their rights to these godforsaken places in this country for indefinite confinement. The executive order did not refer to Japanese at all. And it was somewhat a common experience for Japanese Americans, because if you look at the Alien Land Act, which prohibited essentially Japanese and Chinese immigrants from owning land, it was written neutrally. And just like the Muslim ban, which doesn't specifically talk about Muslims or Arabs, the executive order was written neutral on its face. I mean, it's so obvious that these apply to a specific group, and it's so obvious that it's a result, in my mind at least, of some type of discrimination. And yet to name a targeted group would undoubtedly affect the effectiveness of that particular order. And if you couple that with contextual circumstances, the racism exhibited by General John L. DeWitt, the public opinion at the time against Japanese, for example, you can figure out, if you're not an idiot, that this applies to Japanese Americans. We were at war with Germany and Italy, and so it's obvious that there were people in those communities who might be suspect as well. The FBI had files on pretty much all of the folks they determined dangerous. And so some of those folks were rounded up, but they weren't taken en masse as Japanese were, which included citizens. And I think if you look back, that's why that history of racism comes into play, because you didn't have history of racism for that many years against Germans or Italians. And secondly, if you look at how America or this country has treated Asians as exotic, as inscrutable, as unknowable, as unassimilable, and that's kind of a code word that is used in many contexts to justify discriminatory treatment. you could understand that Japanese Americans were singled out. They were not well known. They did not have the, quote, European customs, unquote, that were a pass for Germans and Italians not to be taken away en masse. The military had direct authority to issue these orders of banishment and exclusion, but there were opponents within the government. Members of the Justice Department didn't feel that this was fair or right or necessary. Even J. Edgar Hoover, who's no friend of civil rights, was against the exclusion. In fact, he declared that, look, I have files on everybody in this country. I know who's dangerous and who's not. So we don't have to take away these people as an entire racial or ethnic group. We can identify the dangerous ones. And so there was resistance within the government, but their voices were drowned out. Part of it, is pure politics, and that's where Earl Warren cut his teeth and got his power base by declaring that Japanese Americans were dangerous. And one of his famous comments was, the fact that no sabotage or espionage has yet occurred is disturbing because that means that it's probably going to occur by Japanese Americans, which is, of course, absolutely illogical. But there was elections during that period of time. Earl Warren is very ambitious, as were a lot of politicians. There was also war hysteria. There was racism. And if you combine all of those different elements or different factors, you're pointing toward a civil rights disaster. I think the politics of fear have been a staple of pretty much every country. I wouldn't just single out the United States, but fear drives people to do things and gets other folks elected. And that's happening in Europe today, for example. And so I think it's a very common principle that we should not be surprised at, but we should be very careful when fear is used as a motivating force for elected officials to promote as part of their platform. That's divisive and that's dangerous, and that leads to these terrible conclusions and actions by the government. If you read By Order of the President, it's a book by a guy named Greg Robinson. FDR was essentially a white supremacist. He was a eugenics devotee. He felt that Japanese were unassimilable, and yet he suppressed a lot of those opinions. And to be fair, he did have some very complimentary views of Japanese, but I think he was very isolated. He's in Washington, D.C. All this stuff is happening in California, where the growers and the farmers are demanding the ouster of Japanese because they were competition. Politicians are screaming for the incarceration. And so I think he was pretty isolated. I mean, if his wife, Eleanor, were president, this would never happen because she was very much more sympathetic and understanding of the human tragedy that was about to unfold. The camps were not camps. They were prisons. There were barbed wire on the outside. There were guns and guard stations with the guns pointed in. They had common latrines without doors. The food was terrible. Inadequate medical care. They were placed in some of the worst locations you'd ever want to visit because it was very hot and humid in the summer. It was cold in the winter. I was in Manzanar a month ago, and while it was fairly benign, it was still 90 degrees, and it was fortunate because the wind wasn't howling and throwing sand everywhere. They lived in dusty barracks, 2 to 3 family at a time. There were cracks in the walls, so they had to stuff newspaper in to stop the wind from blowing in. They had no personal freedom. So I think the worst damage was not just the physical difficulty of living in these conditions. It was the abject humiliation. It was a shame that was imposed upon these people. The loss of dignity is a subjective notion, or the loss of dignity is one of the most devastating things you can experience as an individual, especially in a country that claims to value individual freedom. The government tried to sell this as model cities where people have enough to eat. They play baseball. And so they're just showing a very small slice of how bad these conditions were. And as part of the proof of that, Dorothea Lange, the famous photographer, was commissioned to take photographs of the prisons. And her pictures were not flattering. They showed terrible conditions, people in misery. And so those photographs were suppressed for years until this last year, 2018, when they were opened up. And you could see that there's another side to the stories that the government was trying to sell to the American public. The stories that they were selling was that we're doing this for their protection. They live in great conditions. They get 3 meals a day. And that really did sell to the American public to this day. They say, well, they were lucky to be in these camps when they were really prisons. They didn't have to work. They had 3 meals. They had great medical care. And yet, how much do you pay for the loss of liberty? How much is that worth to you? Is it worth 3 meals a day? I don't think so. And truthfully, the conditions were abysmal. They were dismal. It was an awful place to be, not only in the geographic locations, but in the type of lifestyle, services, amenities you could have when you lived at home in Los Angeles or Seattle, Washington, or San Francisco, and now you've got to live in these like barracks in terrible conditions. I think those conditions were not well known to the American public, partly because of the propaganda. And so folks thought, well, these folks are lucky. And the other thing they didn't show very much, they didn't show barbed wire in any of those, or the guns pointing in. So they look like, quote, camps. Japanese Americans, when they left the prisons in the mid-40s, did not want to talk about this. So there was very little literature. There's very little commentary about what happened to them. There were legal issues that were, publicized, but they really wanted to go back to their homes to rebuild their lives. They felt that they didn't have time to dwell on these terrible injustices. They had to make a living. They had to raise their families. So all of that was suppressed for years by the Japanese American community until the Civil Rights Movement. And the Civil Rights Movement sparked an interest. It sparked or ignited the imagination of Japanese Americans to discover what really happened. And that led the Japanese Americans down that path to self-discovery, to finding their voices, to talking about what happened, to writing about what happened, to the point that many in that community were terribly outraged because they had suppressed all of this anger or this bitterness for years. And now when people were writing about it and talking about it, when African Americans who blazed the path for Japanese Americans to begin talking about civil rights and wrongs, that Japanese Americans began to open up, and more information became available to the public at that time. I've read about the cases and the incarceration. One paragraph in high school. I read a little bit, maybe 5 paragraphs in college. And when I read the Korematsu case in law school, it just sparked an interest to understanding what really happened, because it was at the same time the third world strikes were exploding in the country, and that those strikes, part of the goal was to discover your true history. And as I learned more about what happened to Japanese Americans, the more I realized this was a terrible, terrible civil rights tragedy. And at that point, of course, my interest was sparked, and then I taught at Berkeley and learned more and more because I had to learn the materials to be able to teach the classes. And that probably put me on the road to not just self-discovery, discovery in relationship to this country's history. The original cases began in 1942 and 43, and a lawyer named Ernest Bessig from the Northern California chapter of the American Civil Liberties Union approached Fred and asked him if he would be a test case. And Fred, who was really upset about being imprisoned and about to be excluded, agreed to do this. So ACO prepared a test case for Fred. Fred challenged the exclusion and detention of Japanese Americans. His case went up on appeal with two other Japanese Americans who challenged the military orders, Gordon Hirabayashi and Min Yasui, in Seattle and Portland, respectively. And Fred's case was heard in San Francisco. And eventually all three cases found their way to the Supreme Court. In 1943, Fred's case was sent back down to the Ninth Circuit. And this whole record, or this whole journey of those three cases was manipulated by the Supreme Court because it was a controversial set of cases. So Gordon and Min's case were heard first on the issue of curfew and exclusion in 1943. And so the court ruled in Gordon Hirabayashi's case only on the issue of curfew. It skipped the issue of the exclusion, which was essentially a stratagem by both the government and the Supreme Court to avoid dealing with the larger deprivation, exclusion versus. So the court in Hirabayashi laid out the rationale for upholding the curfew and later the exclusion. The problem with the court's opinion is they had no evidence to prove that Japanese Americans were disloyal or had committed espionage or sabotage because no Japanese American had ever done so. So they were left with a barren record on Gordon's case. So they essentially had to manufacture a rationale. And they created this rationale called the racial characteristics or ethnic characteristics, using peripheral facts that had little bearing on whether you're going to commit sabotage or espionage. Like Japanese Americans worshipped Shinto. They sent their children to Japan for education, that they lived near sensitive military facilities, even though the facilities were actually built after the Japanese had settled there. And the Japanese Americans spoke a different language. They sent their kids to Japanese language schools. They went on and on with these sociological, cultural facts that did not say they commit espionage or sabotage. And they had to do this because they had no other option to justify what they were doing without the evidence of any actual overt acts of espionage or disloyalty. So based on that, essentially they concluded that these ethnic characteristics determine a predisposition to disloyalty. And on that basis, they upheld the military judgment. One of the interesting things I've always found was that the holdings they made in Hirabayashi and later Korematsu were extremely weak. They'd use the dreaded double negative, which English teachers cringe at. We cannot say that the military judgment was unfounded. We cannot say that the authorities did not have reason to believe blah, blah, blah. And, it's like going home on Valentine's Day and telling your significant other, honey, I cannot say I do not love you. It's not a strong way of making a conclusion or a declaratory statement or a declaration. And yet that's what the Supreme Court did because you can smell the weakness in that decision because they had no evidence. And yet they had to bow, they felt, to the military. They were in a time of war. They had some of the most esteemed leaders in the country who had produced this travesty, Franklin Delano Roosevelt. And so they upheld the decision in Hirabayashi. And a year and a half later, Korematsu's case comes up. But it's a more serious claim by Fred Korematsu that it's not only the exclusion, leaving and banishing, getting banished from my home, but to be detained in a prison without due process rights based on racial discrimination. And so Fred's case raised some more difficult issues for the court. So, for example, the court in Hirabayashi ruled 8-0 in favor of the government. In Fred's case, it was now 6-3. There were some vehement dissents that are classic statements of a dissenting justice at the time. And while they use the same rationale as Hirabayashi, the decision itself is if you break it apart, if you deconstruct it, it's ludicrous. It says Korematsu was not excluded from the military area because of hostility to him or his race. Well, what other reason was he excluded? No other group en masse was excluded other than the Japanese. And it also starts with an incredible magniloquence of how important our rights are. You know, that we can't take away our rights in the emergency unless there's a great imminent danger. And they go on to say other statements that, of course, they ignore. Then finally, one of the most, I think, problematic parts of the Korematsu decision was its deference to the judgment of the executive without examining the facts. They say, what you say that they're a danger, we're going to accept your rationale. And that totally abdicates the role of a court, who's supposed to declare that nobody is above the law. And we have the right to examine your rationale for why you're saying this is important enough to imprison that many people for that long. And so Fred lost his case in the Supreme Court in 1944 based on the rationale that Japanese have these characteristics that predispose them to disloyalty and possibly espionage and sabotage, and also because we are going to defer to the military judgment or the executive judgment. All of them physically denied in some level the orders, and it's really extraordinarily complex. But Fred had challenged both the exclusion and the detention in the Supreme Court. And the manipulation that occurred in Gordon's case was, Gordon was sentenced, he was convicted of refusal to obey the curfew and the exclusion orders, the orders to leave. And he was given 30 days for each count. Okay, so a total of 60. Gordon objected, and he objected in a strange way. He said, "Judge, can I have 90 days? I mean, maybe the first time in history a defendant had asked for more time." And the judge said, "Why?" And he said, "Because I researched this, and if I get 90 days concurrently, then I could go on a road crew. I'd rather be in a road crew outside than indoors." The judge says, "I'll indulge you. You can have 90 days. The sentences are concurrent." That means the sentences are both merged. The 45 days each are going to be, or 90 days is merged for both convictions as opposed to stacking a 30-day on a 30-day to make it 60. Well, the court fastened on that in his case to not have to deal with the exclusion. So the court said, well, we're going to decide the curfew, which is not a huge deprivation of rights, but we're not going to decide the exclusion because the exclusion, the sentence was merged. So even if we rule on one versus the other, he's still going to have 90 days. And it was kind of an artifice. It was a manufactured way of avoiding the curfew and the exclusion issue, which is a more difficult issue to decide. And so when Fred brought his up, his case was both the exclusion and then the imprisonment. And those two were very serious. And so the court had given itself a year and a half to try to get itself together from the 8-0 decision, where there were hints of dissents, even in Gordon's case, to get to Fred's case to the point where they had enough to hopefully hold that a majority together. And so what the court did there was rule only on the exclusion, and later on said, well, because Fred didn't raise detention as an issue earlier on, we're not going to even decide that. And so they avoided even the more serious of all charges, the imprisonment, as a way of manipulating the decision to come to a conclusion. And part of the hypocrisy of that is that even in the Korematsu decision, it says that, we don't have to deal with the detention. There's plenty of time to deal with that later. Well, later is 2 cases later. And in 2 cases later, there's a case called Ex parte Endo. And she raised detention as a constitutional issue. And the court said in Korematsu that we'll deal with the constitutional issue later. In Endo, they finally ruled in favor of her, but they failed to address the constitutional grounds. So while they say it in 2 cases earlier they're going to deal with the constitutional case, they failed to do so in Endo 2 cases later. So it's so clearly manipulation of a whole jurisprudence of these cases that is, to me, is just one of the irritating, it's a kind word to say, really pissed off, a way that this court system has treated Japanese Americans. The 3 justices dissented. Justice Roberts fastened on the contradictory orders, one order requiring people to stay in one place and another order requiring them to leave. Well, what do you choose? Either one, you're violating the law. But his dissent was not as strong as Justice 2 other justices. Justice Murphy's dissent was scathing. It said, I dissent from this legalization of racism. This puts us in the abyss of racism, this decision. And then Justice Jackson, who was later a prosecutor at Nuremberg, parenthetically, I guess, Justice Jackson composed one of the most quoted dissents, calling this decision, this legalization of racism, it lies around like a loaded weapon, ready for the hand of any authority that could put forward a plausible claim of an urgent need. And what he said is, by institutionalizing this decision, this gives a precedent for any kind of discrimination you could declare on the basis of without facts. So it's called the loaded gun dissent, and it's used over and over because it's so powerful. They teach these cases in almost every constitutional law class for law students, and they are abstract discussions about the conflicting rights, the discrimination versus the power of the military, things like that. And so I'm reading these cases, and of course it's very personal because I'm reading about my parents being in prison. And so I'm reading the justifications thinking, well, that's BS. This does not seem to apply to in. And as I learn more about history, I realize the fallacies that were put forward in these cases. And I can even recognize some of the internal and external contradictions, the lack of logic on some of the decisions. And in fact, during law school, there was a project that was led by a professor, a Japanese-American professor, who got a grant to see if you could overturn these cases. And I volunteered for that project. And yet they had enough people, so I was rebuffed. I didn't get to participate. So nobody at that time thought these cases could be reopened. These specific cases of these 3 men could be reopened. Legal critics have looked at these decisions from the start. 6 months after Korematsu, a famous article came out by the dean of the Yale Law School, scathingly denouncing this decision, the Korematsu decision. And similar comments had come out over the years throughout the 60s and 70s about these decisions. But again, it wasn't until the context, the historical context, was discovered and promulgated about Japanese American history that folks started getting the idea that, this was really wrong. And at that time, we'd say, now we understand that the justifications were very weak. And so that's when people started taking notice even more. And as I read some of those commentaries, there were a number of them, by the way, that criticized these decisions. It just made you more and more upset that we could have a judicial system. I'm studying to be a lawyer. My job is to promote justice. And to see this kind of thing happen in the Supreme Court by these supposedly wise justices, and it's personal to my family. I received a call from a man named Peter Irons. He was a professor and a lawyer, and he had discovered evidence that there were lies presented to the Supreme Court, that the record was fraudulently manipulated and manufactured to justify the upholding of the Hirabayashi, Yasui, and Korematsu convictions. And he asked if I could help with the cases. And I told him, that I'd like to see the evidence first, because, this sounded miraculous to me. And sure enough, he had all these memos from the department's own attorneys and from other sources, which proved exactly what he was saying, that the entire record was manufactured to win these cases at all costs, even though they were false claims that were being made in the Supreme Court. So I helped put together a legal team, and we gave him an audience. We saw the documents. They were exactly like he said they were, and essentially smoking guns. And we thought, yeah, we could do this. But are these men still alive? And Peter assured me, yes, they are. And they're all willing to stand up again and challenge their convictions. So that's how we started on that set of cases. He had received my name from a couple of sources, lawyers that I didn't really know very well, partly because I had done a lot of impact cases, which was suing, the government, for example, and suing in class actions. I've had, cases. I had cases in Washington, Spokane. I had cases against the San Francisco police, against California Blue Shield, and in my public interest life when I was doing so much more of that. Peter got my name from one of Minoru Yasui's attorneys in Los Angeles. And so he wanted to find somebody on the West Coast. And an interesting thing about Peter is that he wanted to make sure that this whole effort was led by Japanese Americans. But then, of course, there were not a lot of Japanese Americans that were doing public interest work. In fact, there were not a lot of lawyers of Asian descent at that time when I started practicing in the dark ages. So, that's why I got the call. As a lawyer, if you get emotional and too emotional, it clouds your judgment. So we had to distance ourselves. We understood the mission was significant and historically possibly important. But at the same time, we had to make sure that we were objectively evaluating the case itself, the facts, the chances of winning, the legal arguments. As time went on, of course, we got more emotionally invested. And deep down, we were very much so invested, because most of the attorneys, our team, were Sansei. They were third-generation Japanese Americans. And so they had been invested in general, but I think we pretty much suppressed a lot of that in order to keep our eye on the prize, which is to win these cases. The core of the argument was that misconduct tainted the entire process in the Supreme Court. And because of that, it caused what they call a manifest injustice. And if a manifest injustice it can be proved with newly discovered evidence, which was Peter Irons' discoveries and Aiko Yoshinaga Herzog's discoveries, then you can reopen your case and you can get your conviction thrown out. So our whole argument was this was a fraud on the Supreme Court, and it was a deliberate, intentional misrepresentation by court officers like the Solicitor General that led to a monumental injustice. That was the basis of our argument. Fred was very quiet and reserved when we first met him. Of course, he changed over time, but he was very enthusiastic, which surprised us, because we didn't know. We knew Gordon and Min were, one was a professor, one was a lawyer. Fred was a draftsman and a welder when he got arrested. And we felt that we didn't know Fred very well. But as we progressed, we could see Fred was really one of the strongest advocates for his own rights, and not just for himself, for others. And I think it has to be mentioned that Fred and his wife, Catherine was part of that team. She was a Caucasian woman from South Carolina, and just a brilliant woman who helped us both legally and politically. She understood things and was very helpful to us. Fred had a strong sense of right and wrong, and things in some ways were very simple to him. He was an American citizen. Why should he be treated any differently than others? And you compare him to like Gordon and Min. Gordon had a rationale that to accede to the military orders would be like waiving his citizenship rights. Min had a legal argument. This is discrimination. I should not be a part of this tainted process. Fred was very simple. He said, this is just wrong. And that simple strength was as powerful as any other rationale you could ever discover. We went through a series of hearings, and we went through more what we call discovery, obtaining information. And at the final hearing that we were supposed to have, we argued that Fred's conviction had to be overturned. And not only that, we had to have findings of facts. We had to have conclusions of law. We needed an opinion from the judge that what was done to Japanese Americans was wrong. And it was necessary on many levels, not just for our Fred's satisfaction of the Japanese American community, but it was for the battle of redress in Congress that was waged at the time. And we needed a legal opinion that would counter the 1943 and 44 decisions by the Supreme Court that opponents of the redress movement and redress for Japanese Americans were using to try to defeat that redress, $20,000 in an apology for Japanese Americans. And at that day in court, they had to change the courtroom because so many people were wanted to go, and they moved it to a ceremonial courtroom. And so the work teams from the other Hirabayashi and Yasui cases came down. The audience was filled with just absolutely packed. I mean, people were in the jury box, reporters there, counsel, and a number of the folks, perhaps majority, were Japanese Americans who were there to witness the trial they never had. And they were a majority in the courtroom. I opened with my argument, which was we're here today to seek a measure of justice denied to the Japanese American community and to Fred Korematsu some 40 years ago. And I went on to argue why findings of fact were absolutely necessary, why she had to publish an opinion, not only overturn his conviction, but we had to have a written opinion. At one point, the other attorney for the United States government gave his rebuttal, which was essentially, let bygones be bygones. And it was a very weak argument, which, of course, nobody bought at the time, including the judge. And then we asked for the judge to indulge us and let Fred speak. And unusual for your client to speak in court, but Fred gave a very powerful plea to talk about how he had come to this courtroom years ago in handcuffs, and he is here today to make sure that this does not happen to any other American again. And with that, the court closed the argument. And, you know, in courts, in argument, when you argue in court, the judges usually take it under submission, which means they don't make a ruling and they walk off the bench. Well, she didn't do that. She gave us her oral opinion directly from the bench, and it confirmed and validated almost everything we said, that there was misconduct, that the government attorneys knew it, that some of the decisions to incarcerate Japanese was propelled by racism, and had the court known of this contrary evidence that contradicted their own arguments in the Supreme Court in 1943 and 44, the decision might be different. And with that, she threw out Fred's 40-year-old conviction. In that courtroom, as I was arguing, you could hear people sniffling and crying, and Japanese tend not to show their emotions, but you can sense the intensity of what was going on in that day for the trial they never had. And after we left and went outside in the hall, folks were crying, hugging. They were really ecstatic about having their day in court through Fred Korematsu. And after that, the Japanese-American community, with the findings especially, which were very powerful, really embraced Fred Korematsu and what he had done. And the legal case that we had brought that was doubted by a lot of people that we would ever win these. In order to get back into the Supreme Court, you need a factual situation that is exactly like or similar. The quorum nobis is a special kind of procedure that only gets rid of the conviction of the defendant. It doesn't overturn the Supreme Court ruling, because the Supreme Court's ruling it doesn't overturn the Supreme Court ruling. So you need another factual situation that is fairly similar. Enter Trump versus Hawaii, and that is as close as you can get to one of those situations where a court could overturn Korematsu. Trump versus Hawaii was a challenge to the cold travel ban against predominantly Muslim countries. It was really a Muslim ban, and if you review the statements made by Donald Trump that were anti-Muslim, that wanted them to cease immigration here, to erect blockages to their immigration, that led to eventually an executive order to block immigration from Muslim countries. The order was amended a few times, but it was really predominantly Muslim countries. So it was religious profiling, unlike the racial profiling Japanese Americans endured. And so to cast a group with such broad strokes, not on the basis of individual danger, which was done to Japanese Americans, made this case quite similar to the Korematsu, Hirabayashi, and Yasui cases. So it found its way in the Supreme Court. Trump had lost on every circuit court, and Trump's executive order lost on every district court and circuit court before it got to the Supreme Court. And when it got to the Supreme Court, Justice Roberts upheld the Muslim ban, and he refused to look at the report upon which the Muslim ban was based, because the government refused to produce it. It was not dissimilar to the suppression of evidence, which led to the Korematsu decision in 1944. Justice Roberts failed to do any kind of active interrogation or using rigid scrutiny, which is the standard, to look at this as a case where you have to look very closely, test the evidence, determine whether there was a justifiable rationale. Instead, he almost said, because the president said it, we're going to believe it. And that's the danger of that decision, because it is really Korematsu revisited. It's an echo of history. Justice Sotomayor dissented. And in her dissent, even though Justice Roberts claims that Korematsu was overturned, she says that this is essentially a hollow victory, because it redeploys one bad decision for another. And if you read the Roberts, quote, overturning, unquote, of Korematsu, it's not really overturning. Symbolically, it's very important, but it's a very hollow victory in the sense that he parses his words. Korematsu was overturned in the court of history. It was wrong the day it was decided. And so in saying that he overturns Korematsu, in the next breath, he upholds the travel ban by deferring to the president. So that deferral to the president, or deferral to the military or executive, is the most dangerous type of precedent you could have. It's the same one that was used in Korematsu. It's the same one that was used in Trump versus Hawaii. I've always felt that, and history has shown that there's always going to be a tension between civil rights and national security. There's going to be a balance somewhere along. But there also, in my mind, and the Korematsu case proves this out, as well as Trump versus Hawaii, there's got to be some transparency. You've got to have some published rationale. And of course, in times of war, you can't tell military secrets, but somebody's got to be able to offer enough evidence to justify, which is essentially a grave violation of civil rights, or racial profiling, for that example, or religious profiling. And in order to do that, somebody has to be able to test the evidence. And that somebody is usually the courts. When the courts step down, when the courts abdicate, when they give up their role, you only have two branches of government, because the president is going to get to do whatever he wants. That whole checks and balance system falls of the failure of the courts to exercise their proper role. And so I feel that when you have these national security justifications for doing anything, given our lens of history as Japanese Americans and what happened to Korematsu and Hirabayashi and Yasui, we are skeptical. And we feel that the courts need to do more to ensure there's some transparency, or the executive or government needs to do more in order to provide a honest justification that is rational and leads to the particular executive order or order that is announced. You know the adage, those who fail to learn the lessons of history are doomed to repeat it. You know, that's a very simplistic way of explaining a very difficult concept, history. It's very complex because there's a lot of what I've realized is that lots of people understand history, but for other reasons fail to apply it. Think Vietnam, think Afghanistan, think of the Japanese-American incarceration, think of what's happened to the Muslim registration. They're repeating history all the time, and in large part because of political expediency. And history can be distorted too. History could be changed, and there are revisionists who say the Holocaust never happened. So that history is a dynamic process that needs to be reaffirmed in its correctness all the time. Every generation has to relearn this and know this again, because there are people who deliberately distort what happened. There are people who will fail to learn or apply history because of political expediency. So it's a dynamic concept, and I use the example of avocados, because years ago they told us avocados are bad for you. You know, I love avocados. And later on, of course, they find out, oh, no, okay, it contains really the good fat, and it's very good for you. You know, it's a Guacamole Relief Act. And I was delighted to be able to eat avocados without guilt. But that's an example of how things change, and you have to, understand that history is a dynamic concept. And just because history, as declared in one point in time, doesn't mean that history is the same history that you will learn today. The biggest point, though, is that history is manipulated, that history is subject to political expediency. Decisions you make based on past history are not always made, just because people feel that out of expediency they want to make their decisions in a different way or a different direction. You know, I do have some empathy for people who were living on the West Coast at that time. You know, they were ignorant. They did not know who Japanese Americans were. They were scared because of the politician rants. So they were not always the most informed people. But there are times when history is very clear. When you massacre 6 million Jews, how are you going to justify that by, it was the times? No, I don't think so. How about segregation? There are times, or slavery. There are times when, you can understand why people do things or how they believe that way, but it certainly doesn't justify these kind of injustices. I think it's incumbent upon citizens to speak out against injustice. And it's not an easy thing to do. It's very difficult. And I think, we rely so much on our political leadership. So it's up to us to elect good leaders. But on an individual level, I think speaking out against ignorance, speaking out against bigotry are important things to do, because on a maybe a macro level, it may not seem to make any difference. But on a day-to-day citizen to citizen level or person-to-person level, as you change the culture of the country by either example or by speaking out or by joining with other people to try to make a difference, changing the culture is a long, long process, but it's something that I think we need to be committed to do as everyday citizens. When I was in college, we studied the great man. They called it the great man. They didn't say great woman. The great man theory of history. They had all kinds of different theories about history. And I really believe that, I still believe that masses of people create the history. And occasionally, it isn't always the case. Sometimes a great man will stand up. Martin Luther King Jr., Malcolm X, changed the direction of this country to fight against racism. But I think people like Fred is one of the best examples of someone who was an ordinary citizen. And I hate to use the word ordinary, because he was an extraordinary citizen, or he was an ordinary citizen put in an extraordinary context. And so many times those people stand up and do something heroic. And it doesn't even have to be heroic. It could be something that moves us forward just a little bit. So I believe that everyday people, all of us as Americans, can contribute to the movement of social justice forward, that arc of history or that arc of justice that Martin Luther King Jr. talks about. And if you see yourself in isolation, of course, you can say, well, I can't make any difference. I'm just one person. But if everybody saw themselves like that, of course, nothing would happen. But if you see yourself as a larger, growing, evolving community of people, like a part of a river that is flowing forward, then you understand that you're part of a larger flow of events, of culture, of society that eventually can achieve some social justice down the line, upstream. My father was a Democrat until he was put into the prisons by FDR. After that point, he became almost a lifelong Republican. And his explanation for that, as which I discussed with him when I was of voting age and wanted to be a Democrat, is he said, well, they put us in the prisons. And so he was embittered, and that was his way of, at least showing displeasure, I guess you should say, at being treated that way by Democrats. But he was also a small businessman owner, so I'm sure that led into it. And yet he never voted Republican until my mother, who was pretty much always a Democrat, convinced him that he had to vote Democrat when the Vietnam War was raging. And so he voted for Eugene McCarthy for the first time. And so after that, he stayed as Democrat, which was interesting to me because maybe he was retired. But no, he harbored a lot of bitterness that we never saw. And we didn't see that until the redress movement started and loosened the tongues of Japanese Americans. It helped them reclaim their political birthright, their legacy of being American citizen. And at that point, he started talking more and more, and we learned more and more. This is way when I was in my mid-30s, so it was a long time after my youthful years. But I think once his voice was loosened, he was able to tell us so much more about how upset he was. He showed us documents, which I still have, and was quite animated. My parents were alive when we argued the Korematsu case. My father passed away about 4 years later after the case, but he was extremely proud, and not just of me, but of the fact that he had some vindication for all the lies that were told about Japanese Americans, all the racism he endured in his lifetime. So I think he felt good about the idea of redress. He never lived to get his $20,000 or an apology, but he was certainly quite elated that he knew he never did anything wrong, and now it was proven in court. Reason is a difficult counterweight to emotional decisions. Over the years, as I've done enough trials and to know that juries pretty much respond emotionally to the evidence, so to speak, and then anchor and justify their decision in some intellectual basis or reason. So we've seen that in the most recent elections. People will vote against their self-interest because they have an emotional connection, and so their self-interest, which is rational, does not come into play as much. I think it's a very difficult proposition to change people's emotional justification. I think you have to engage in dialogue. I do believe that you can change people by talking to them, but I think you have to talk to people in a manner in which you can communicate. So it has to be in experiences they know about or can relate to. It can't be overwhelming them with facts necessarily. And it has to be appealing in some ways to their own self-knowledge. It has to appeal to them through their own experience or commonality of experiences. And in that sense, I think you can reach people because you've got to get to their heart as much as you've got to get to their minds. And if you don't get to them emotionally, I don't believe you can create intellectual justifications that are so purely correct that you're going to change somebody's mind. But I do believe that if you could do it in a way that relates to their commonality of experience or their experiences, you can actually create a dialogue that then allows people to either think about what you might have said or at least have some change of heart based on what you've agreed upon. You have to describe what the prisons were like, because just saying, well, there was terrible water, if you just say there was terrible conditions, you have to be a little more specific. And you want to talk about loss of dignity because people could understand what that feels like to be really humiliated. People might not understand sleeping in cots or having to go to open latrines or getting inadequate medical care. Those are pretty abstract concepts. But if you talk about the humiliation that people suffer when they're treated as like animals or less than human or less than citizens, people all can relate to the idea of humiliation more so. So I think that's one way of doing it. The other way is to connect to their own experience of racial discrimination. Because if you're talking to especially a group of people of color, they tend to get it, and or women too. They tend to get things a lot easier. So to that extent, you talk to them in terms of racial discrimination. Others, especially in law school, there is a sense of justice that people have, and it may be different kinds of justice. But if you explain, like the Korematsu case or the cases that we worked on, in terms of the kind of manipulation, the fraud, the misconduct, people have a sense of fairness where they'll say, well, that was unfair. And they could relate to that. They might not agree with you in terms of other proposals you have or other ideas, but a sense of justice, I do believe that so many people have that. And I think appealing to that with concrete examples is helpful. There are different parts of the Korematsu decision. The part where it says you can incarcerate an entire group of people without due process, I think that's not only overturned in the court of history, but I do believe that legal commentators have damage that precedent to such a degree that it won't be used again. The precedent that you can defer to the president or the executive without an examination of the evidence is really a dangerous one that is now even more strongly embedded in our jurisprudence through the Trump versus Hawaii case. That's the danger of that precedent, and it's the one that we're going to have to live with. And at some point, you're going to have to hope for another branch of the government, other than the judiciary, to step up and make a difference in terms of the decisions that are not going to be overturned by the judiciary.